May it please the court, the defense moves to dismiss count 2 criminal threat as this rape compliance comment was protected free speech under Section 2 of the First Amendment. Now, to determine whether this client's comment was indeed a true threat, we must consider the 6 elements outlined by Calvin 1300 that requires of a statement to constitute a true threat. First, element 4 states that the threat must be so clear, immediate, unconditional, and specific. Yet the statement in question, however, does not contain any mention of when this threat might be carried out, nor how or with what the threat might be executed. The statement merely contains vague sentences such as, I'm coming for you, I'm going to get you, or I hate you. Hate crime is not a speech.
But now when words are vague, can't this court, under the Supreme Court decision of In re George T., take into account the context, such as a history of animosity, in order to convert what would otherwise be vague comments not amounting to a true threat into a true threat?
Yes, I agree, Your Honor. George T. does outline 3 surrounding circumstances that must be observed when the comment is vague, and the 3 circumstances are the threatening gestures, history of animosity, and conduct suggesting the immediate possibility to carry out the threat. However, in this case, none of those 3 surrounding circumstances are present in the court today, and the date of August 14 will prove, and I will show you the evidence that there were none of those 3 surrounding circumstances. Would you like me to explain why there were no 3?
Yes, please proceed.
Now, as for the threatening gesture, the message was sent via electronic communication. So there was no threatening gesture, as a gesture is implicitly a physical form of communication.
How do you square DC versus RR with your case? Doesn't that case directly contradict the propositions that you're making? Because in that case as well, a computer keyboard was used, and the court held that amounted to a deliberate and careful decision to make the comments in question.
Yes, Your Honor. The case of DC versus RR stated that the statement was indeed a true threat because of the message and its transmission. But the case in DC versus RR is different from the case at bar, because as we can see in the case of RR, there was deliberation shown through the specific actions that the defendant had mentioned to carry out, such as bashing the victim's head in with an ice pick, and the threat to kill that occurred 3 times present in the case of DC versus RR. However, in this case, there is no specific action for Smith to be fearful of, and there is no specific action that Ms. Klein mentions anywhere in the threats that she would carry out.
Please proceed. Thank you.
So instead, all we see in the comment is an angry Ms. Klein, simply expressing her emotions and frustrations, similar to the defendant in the case of Ricky T., in which the student who gets slammed in the face with the door by the teacher simply expresses his anger with a rude threat containing curses and the phrase, I'm going to get you. But due to the statement's lack of immediacy, paired with the fact that this teacher had not made any calls to the police, the court upheld a ruling of not a true threat. Which leads to my second point, elements 5 and 6, which states that Sawyer Smith must be in a state of sustained and reasonable fear. However, the evidence of the day shows that Smith was not in fear, because in reply to Ms. Klein's comment, Smith, quote, laughed out loud, commenting as if, you're done now, bye.
But Mr. Smith was very concerned with how he came across to the public, hence his sideline career as an influencer, right? Wouldn't he have had every intention to want to convey to his public that he was not particularly concerned by these words which were possibly intended to further humiliate him?
Yes, Your Honor, he did have a reputation to uphold, and so he did not want to show his fear to his followers. But this is not evidence for why Smith did not show or fear to his family or acquaintances, or to the police that are there to help Smith, and could do so in discretion. The argument for why Smith did not show fear to his followers cannot be applied to why Smith did not show fear to the police or the
How did he not show fear to his family?
We could see from the process or the events of August 14 that Smith, after receiving the threat, simply carried about with his day and ended the night watching him in bed, and as the statement says, without alerting anyone.
Thank you. Please proceed.
So we must consider Smith's fear that was involved. And in the threat itself, there was no clear action for Smith to be fearful of. Also, subsequent to the threat, we could see that Smith had gotten swatted that very night. But when Smith had gotten swatted, when she was in the ambulance, when he was going to the hospital, he immediately thought of Reagan Klein. Or he did not show fear because the swatting incident was not a direct correlation to the case at bar. The people will try to prove that the swatting incident showed conduct suggesting to kill. However, that simply is not the case because Sawyer-Smith must have been in fear from the statement itself directly and not from the circumstances itself that was the conduct suggesting to kill. Also, there was no history of animosity. There was a history between Reagan Klein and Sawyer-Smith, yet not only must we consider the relationship between these two parties, we must consider the relationship between Sawyer-Smith and that of the account of Hayden Carlton. And when we look at Mr. Smith's witness statement, he writes thus: "I was feeling on top of the world that I had finally beaten this stupid online attack by the fake Hayden Carlton account." So not only did Mr. Smith deem the true threat or the prior attacks by Hayden Carlton account to be stupid, he knew it was a fake, that it was meant to embarrass him. And on that same day, it was the same Hayden Carlton account that had threatened Sawyer-Smith. So Sawyer-Smith, knowing that, unfazed, wrote the statement, LOL. And it is for these reasons, because the threat itself lacked unequivocality and specificity, and immediacy, and because Sawyer-Smith was not in a state of sustained or reasonable fear, that the defense requests that Your Honor grant us the 995 motion to dismiss count 2. Thank you.
Thank you, counsel. Does the prosecution wish to present a summary of its argument?
Yes. May I proceed?
Yes, you may.
Good afternoon, Your Honor. The people respectfully ask that the defense's 995 motion be denied. The motion we are here for today discusses probable cause, and if there is any, it must be denied. The defendant threatened Sawyer-Smith after months of rising animosity. A catfish account was created under the fake alias known as Hayden Carlton by the defendant and two fellow co-workers. At first, this account was used to bait Sawyer-Smith into a fake online romantic relationship, and when that didn't work, the account was moved to purely embarrassment and harassment tactics. All of this came to a head when the defendant threatened Sawyer-Smith by commenting, "You deserve to die. I'm going to get you for this. You just wait. I hate you."
But isn't it true that by saying you deserve to die, he's not saying he's going to accelerate the process of death? He's saying at some point in the future you deserve to die. He's not saying I'm going to kill you, right?
At the end of the threat, it says, "I'm coming for you. Watch your back."
But does that necessarily imply an intention to commit an act of violence as opposed to a further act of humiliation?
Not that specific line, but when you look at the entire context, it does give a gravity of purpose to the threat.
And what context is that?
There was a history of animosity for over a number of months, and there was a post-threat event where, as the people will prove in trial, the defendant did in fact send a false text tip to the East Flamingo Police Department, resulting in the SWAT team raiding Sawyer-Smith's home, Sawyer-Smith falling down a flight of stairs and suffering from great bodily injury.
So I can take the evidence tending to link, and that's all it does at this stage of the trial, Ms. Klein with, I can take that evidence of attempted swatting into account in determining whether or not this is a criminal threat.
Yes, because if we look at the case of People versus Martinez, there was a threat made, and the next morning a fire was started by the defendant at the victim's workplace, which was linked back to the threat and gave weight to the threat. And in our case, it only happened a couple of hours later. So following the ruling of People versus Martinez, our case has a fulfillment of the threat immediately.
Thank you. Please proceed.
When you're dead, no one will even miss you, you monstrous, slimy person. You think you can stick me with a $34,000 lawsuit and just get away with it? Watch your back, Sawyer. I'm coming for you. California Penal Code 422 states a true threat is made a true threat when the specific intent of the threat, made in writing, verbally, or by means of electronic communication device, is to be taken as a threat, even if there is no intent of actually carrying it out. And the threat must be so unequivocal, unconditional, immediate, and specific as to convey the person threatened a gravity of purpose and an immediate prospect of harm or execution, therefore causing the victim to be in sustained fear. First, looking to the defendant's deliberation and intent. The defendant took time to think out, write out, and post.
Well, is that true? This generation seems to be able to text and type faster than they talk. How much deliberation does that take? And a transmission involves the pressing of a button.
Yes, if we look at the case of DC versus RR, it was deemed to be a true threat because of the amount of deliberation and intent it takes to write a grammatically correct threat at a keyboard for over a period of minutes.
Please proceed.
Does that answer your question?
You did.
Okay. Took time to think out, write out, and post a grammatically correct 6-sentence long threat. Following the case of DC versus RR, which was deemed to be a true threat because of the deliberation and intent, our case has deliberation and intent. Second, looking to a gravity of purpose, we have to look at all circumstances involved. The California Court of Appeals ruled in the case of People versus Martinez that a defendant's words can be vague if the action show an immediate prospect of harm or execution. In People versus Martinez, there is a history of animosity, a threat made, and a post-threat event where the defendant set fire to the victim's workplace, causing damage to the building. In our case, there's a history of animosity, a threat made, and a post-threat event, whereas I mentioned earlier, the defendant set a false text attempt to the East Wamego Police Department, resulting in Sawyer Smith being swatted. Following the ruling of People versus Martinez, our case holds a gravity of purpose. Third, looking to sustained fear felt by the victim. The defendant sustained fear by the victim, The California Supreme Court held in the case of People versus Chandler that a victim can be in sustained fear for his or own safety, even if they do not immediately report it, because it is common for victims to desire not to show it. In People versus Chandler, victim number 2 said bring it on in response to the threat. Yet, once it was later reported, it was deemed to be sustained fear.
Well, that's true. But in this case, that was the visible outward air of insouciance that the victim adopted. But the victim then went to bed and watched a movie. Didn't seem particularly perturbed by what he had read.
Yes, but as you earlier said to my opposing counsel, the victim was afraid of the reputation that they held on social media and wanted to preserve that they were not in fear after this account had been harassing.
Yes, which is why I'm distinguishing between the LOL, the response on the website, and what he did privately. What he did privately, his audience, the audience he was trying to impress, couldn't see what he did. He didn't seem to demonstrate any fear when he watched a movie that night, did he?
His actions did not show fear, but immediately after the swatting incident, when the situation escalated, so the victim did report the fear to Officer Keaton Lopez. May I proceed?
Yes, you may.
In our case, Sawyer Smith might have responded with LOL as if you're done now, bye, but reported to the police immediately after the swatting incident. Did you see that psycho comment Reagan left me? I was totally freaked out, but I wanted to play chill so my followers would see. Showing us two things. One, that Sawyer Smith did not want their fear to be public knowledge, and that Sawyer Smith was in sustained fear for a number of hours after the threat was made. Following the holding of People versus Chandler, our case has sustained fear. In conclusion, Your Honor, the people respectfully ask that the defense's 995 motion be denied on grounds of probable cause. Thank you.
Thank you, counsel. Rebuttal?
Yes, Your Honor. May I proceed?
Yes.
Element 1 of the California and Element 3 of the California state that the defendant must willfully threaten with the specific intent that the statement be understood as a threat. This requires the people to prove that the defendant fulfilled the strict culpability requirement of mens rea. But in her witness statement, we can see that she writes, quote, "In my haze, I commented something stupid on Sawyer's post. Looking back, it was a lot, but I didn't really mean it, and Sawyer knows that." So yes, Reagan Klein was negligent and reckless, but in no way did she intend to put Smith in any fear or harm. She did not intend to threaten Sawyer Smith. Now, as for the case of People versus Chandler, we can see that the people have brought up People versus Chandler to show that victims can show sustained fear and have sustained fear, even and make such statements like that.
Well, one moment, counsel. I'm more concerned about People versus Martinez and the evidence of the fire there being equivalent to the evidence of the text tip here. The fairly vague words used tend to become more serious and threatening if you combine it with the conduct of the text tip, of which there is some evidence.
Yes, Your Honor, but there are several distinctions from People versus Martinez in the case at bar. First, the supervisor called the security after receiving the threats, not after the arson incident. Second, arson was a secondary count to promote count 1, criminal threats, which was the primary incident and not the pretrial motion. And 3, because this threat was not the because the threat was the primary factor that must be considered when looking at the fear. And we can see that Ms. Sawyer-Smith, not from the swatting incident, but from the threats, had not received any fear. We must conclude that Ms. Sawyer-Smith was not in sustained fear as a direct result of the threats. And so the swatting incident must not be considered because the swatting incident is a separate matter, but also because the swatting incident, though it may have caused Sawyer-Smith to be put in fear, is not what must be considered. The threat must be considered, and what the threats caused Sawyer-Smith to be in harm or fear is the primary factor. And so Chandler, we could see that the victims in the case of Chandler took subsequent action, and thus that was the reason why the court deemed that they had sustained fear. However, in this case at bar, Mr. Smith has not shown any subsequent action that might indicate sustained or reasonable fear. After the swatting incident had occurred, Mr. Smith, when the SWAT team was banging on her door, immediately thought that a burglar had been trying to enter. She wrote, "I thought someone might be trying to break in and steal from me." Mr. Smith's immediate thoughts were not that of Ms. Klein or the comments, but he was more concerned for his possessions than for the safety of his own life.
30 seconds.
And not only that, Mr. Smith was in his house behind bolted doors for the entire night without receiving any further statements, gestures, or conduct from Ms. Klein indicating any action to carry out the threat. And it's for these reasons that the defense requests that Your Honor grants us the 995 motion.
Thank you, counsel. Rebuttal from the prosecution?
May I proceed?
You may.
Earlier in my opposing counsel's argument, they brought up the case of In re George T. But In re George T is distinguishable from ours. In re George T, there was no specific target as to who the threat was made out, and it was simply just poetry. In our case, this is a deliberate, intentional threat written on a phone keyboard, then sent, posted, and kept up on the victim's website. A more analogous case to ours would be the case of DC versus RR, as I brought up in my previous argument, where it was deemed to be a true threat because of the amount of deliberation and intent it takes to write a grammatically correct threat. Second, opposing counsel has said that swatting is not relevant in this case, but it is, because the 995 motion discusses probable cause, and if there is any, the motion must be denied. The swatting incident and the defendant being charged with count 1 of false report of emergency is probable cause. The defendant is suspect right now and is the key suspect in being charged with it. Therefore, it is relevant to our case. Third, opposing counsel has also brought up that there is no sustained fear, but I'd like to refer you back to People v. Chandler, where the victim did not immediately report it, but once it was reported, it was deemed to be sustained fear because of the circumstances. And in our case, there was a threat made, there was an escalating level of animosity, and there was a post-threat event where the victim's home had been swatted.
How do you explain the Jackson case? There was a threat to use an AK-47. Far worse threat than what we have here. How do you factor that into your position?
People v. Jackson may be more grotesque and exaggerated, but it's distinguishable from our case because there was no previous animosity and there was no fulfillment of the threat, and the victims were not deemed to be in reasonable sustained fear. And in our case, we have a rising animosity, which would lead the victim to believe that this threat had a weight of purpose to it. We have a victim in sustained fear after the threat was made and said, "Did you see that psycho comment Reagan left me? I was totally freaked out, but I wanted to play it chill." And there was no There's no fulfillment of the threat, and it was not reasonable under the circumstances, but in our case, there was a fulfillment by the defendant sending the false text to him. Does that answer your questions?
It does.
Thank you. May I proceed?
You may.
Going to the case of People v. Chandler, where the victim did not immediately report it, but once it was reported, it was deemed to be in sustained fear. This is analogous to our case, because the victim did report to the police in the ambulance on the way to the hospital after their house had been swatted. Then did you see that cycle call ring? Nothing yet, I was totally freaked out. In conclusion, Your Honor, the people respectfully ask that the defense's 995 motion be denied on grounds of probable cause. Thank you.
Thank you, counsel.